Constitutional Court is expected to hear the IEC's urgent application to have the elections postponed, political parties and the public continue to differ on whether this is the correct decision. Organizations including the ANC, the DA, IFP, ATM, One Movement South Africa, the Makana Independent New Deal and the Forum for Service Delivery will also be pleading their cases before the Apex Court. The Western Cape government, through its MEC of COGTA, Anton Bredell, in his capacity as the 10th respondent, will also oppose the application. And at the center of the dichotomy are the prescripts of Section 159 of the Constitution, which addresses the specific term of a municipal council, among other things, and of course the importance of holding free and fair elections. A lawyer and a member of the South African Law Reform Commission, Advocate Tembeka Ngcukaitobi, joins us now to discuss this matter. Advocate Ngcukaitobi, thanks for your time. Welcome to Morning Live.
Thank you for having me.
So an interesting one, this one, because for the longest time, there seemed to have been a perception that given the Moseneke report, that this was essentially a fait accompli, but it seems not. So let's just take a few steps back. In terms of clarity, under which circumstances may an election be postponed, and which entity would have the authority to do that?
Yes, thank you. That's a helpful start. So the structure of the Constitution contains the Bill of Rights and several other chapters which deal with the constitution of government at a national, provincial, and local level. On the Bill of Rights front, what is relevant is the section that grants people the right to vote, which is in Section 19. So you are entitled to regular elections, as well as Section 1. You are entitled to regular elections, and the procedure by which those elections are to be held is prescribed in national legislation. And then you have Section 159 on the structures of government side of the Constitution, which says that a municipal council holds office for a period of 5 years. It has no provision for a postponement of an election, no provision for an extension of the term of office. And then you have another section that deals with the powers of courts. It comes in two different sections. The one is Section 165, which entrenches the independence of the judiciary. The other is Section 172, which gives the courts the vast and extensive powers to grant a just and equitable order in a case that is within their powers. The controversy at the Constitutional Court that will be fleshed out today is whether or not the Constitutional Court has the authority to suspend the operation of Section 159. The IEC will say, in a case where there is a supervening impossibility, the Constitutional Court is the only court, because they have approached the Constitutional Court by way of direct access. They will say, where there is a supervening impossibility, the Constitutional Court has the power to suspend or render inoperative the 5-year term limit. The DA will contend that there are no circumstances where the Constitutional Court, or any court for that matter, can suspend a provision of the Constitution, and that the correct approach to take is a constitutional amendment which is hosted or driven by Parliament. So those are the two extreme ends that will be debated today.
So let's speak to the Apex Court and its jurisdiction, because KSEC and the DA, as you say, they are opposing on the basis that this court does not have the powers to grant the relief sought by the IEC and those who are concurrent with their view. So what is your view on that one?
So there is a second argument which we didn't explore in my initial response, which is the IEC has an alternative argument in which it says the Constitutional Court has the power to declare that a conduct or law is inconsistent with the Constitution. That is power in Section 172(1)(b) of the Constitution. They will say that the failure by the IEC to convene the election within the stipulated period is an unconstitutional failure. And once that declaration has been made, it is then open to the court to suspend the effective date of that declaration of invalidity. So they have an alternative argument which falls within the powers of the Constitutional Court. Now, for that argument to win, the IEC needs to show that it is just and equitable. On the just and equitable front, they rely on the report by Justice Moseneke, who has examined the evidence, has listened to the experts, and has come to the conclusion that the prevailing circumstances in South Africa do not permit for an election. My own view is that it is not proper for the Constitutional Court to exercise such vast and extensive powers, which include the suspension of the Constitution. But I also recognize that it is not practical to host an election right now. And hence, I'm inclined to the second argument of the IEC, which says that the court must declare the conduct of the IEC in failing to hold an election as unconstitutional. And it is within their powers, once they have made that declaration, to suspend the order of invalidity, and they can suspend it to the date that the IEC proposes would be realistic to hold an election, which is in February of 2022. There's still a big question as to whether or not the February 2022 date is itself a realistic projection. What, in fact, will be the situation in the country by then? Will the infections be down? Will they be manageable? Or will the situation be worse than it is at the moment? But avoiding that vortex of constitutional uncertainty means that the court must act strictly within the parameters of the Constitution and not try and go outside the basic and clear terms of Section 159.
And speaking of those prescripts of Section 159 of the Constitution, and I guess one of the issues there is the term of a municipal council. So
yes. In
this regard, wouldn't it have been prudent for the IEC to approach Parliament as well as the Apex Court, as opposed to, first heading to the Apex Court?
There is a complexity. One can say that complexity is of the IEC's own doing. We must remember that months ago, many months ago, the EFF asked for the elections to be postponed. The IEC was ducking and diving and never made its position clear. Much later, it then shifted the decision-making to Judge Moseneke, who, with admirable speed, convened the commission and produced a report and gave it to them. But at the time when that all happened, it was too late to initiate a parliamentary process. As you remember, the key to a parliamentary process would have been public participation, which would have been prohibited for at least a period of 30 days, whilst the bill is advertised. So if you went through a parliamentary process, you are looking at a minimum of 60 days. And it's on that score that they decided that what would be practical right now is approaching the Constitutional Court, because if you compare it with the parliamentary procedure, it will be quicker and it will also be manageable in the sense that there will be one hearing, one decision. So if they should have approached Parliament, they should have done it earlier. But now they go on an urgent basis to the Constitutional Court, having themselves, in a sense, created that same urgency. But the matter is of sufficient public interest. And my own view is that the Constitutional Court should not be detained by the issue of urgency. It should look into the merits of the case so that if it dismisses the application, the IEC can either move to Parliament and try and initiate a process. Alternatively, the IEC can get on with the job of arranging the election. But you see, if there is a view that the election should nevertheless go ahead, the EFF has made submissions to the Constitutional Court saying, we have not campaigned. We cannot campaign because a campaign will breach the current COVID regulations. So there has to be an adjustment to the COVID regulations, and there has to be a postponement to the date by when the lists ought to be submitted to the IEC. So it seems that the public interest strongly suggests that the Constitutional Court must simply grapple with the merits of the case. And it seems that the correct outcome from the way in which the court grapples with the matter is exercising its jurisdiction in terms of the alternative remedy that the IEC seeks.
And of course, some of the parties that are arguing contrary to the position of the EFF, for example, they would argue that a postponement of the election would amount to a violation of the Constitution anyway. So that sort of argument, how far can they take it?
Yes, if the postponement of the election is on the basis of a supervening impossibility, which is a doctrine that is known in our law, usually applicable in contracts. So for instance, people don't perform with a contractual obligation and they say, I cannot perform. Just like Transnet, for instance, it had to close down its harbor during the riots of July. And it told its contracting parties that I'm sorry, I cannot do anything because there is too much violence around me. So our contract law recognizes the doctrine of supervening impossibility. The IEC today will try and persuade the Constitutional Court that it also applies to constitutional obligations which are time-bound, like an election. So the unconstitutionality only arises if the first argument of the IEC is the be-all and end-all of the case. In other words, the argument that says the court itself must suspend or postpone the election. The main point is that that breaches the doctrine of separation of powers. The courts do not make the law, they interpret and give effect to it. That is its basic tenet. But there will be no unconstitutionality if the Constitutional Court looks at the second argument by the IEC, in which it says, we appreciate that we have not complied with the Constitution, and therefore you should declare our non-compliance as invalid. That is within the powers of the court. And as a consequence of that declaration, you must postpone or suspend your own order of invalidity until February next year. That again is within the powers of the courts. So it seems to me that the second argument by the IEC does not raise questions of unconstitutionality in a sharp way as the first argument does. So I think there is complexity of the first argument, and I'm personally quite skeptical about its potential.
So with regard to the term of municipal councils then, what could possibly then be the ruling in this regard? Because one would imagine that as things stand right now, as per Section 159 of the Constitution, those councils, when their terms come to end, would have been dissolved in terms of the legislation. So what happens in that regard?
Yeah, the simple position right now is that the term of office lapses after 5 years. The Constitution doesn't contain a provision for the extension of the term of office. The Constitution doesn't contain a provision for the suspension of the term of office by the courts. So that's the simple position. So it seems that absent a judgment of the Constitutional Court and absent an amendment, the term comes to an end. And what should happen is that there should be a fresh election. And the IEC must simply put its ducks in a row to conduct that election. So that's the position without this court. But the court is being asked to intervene right now. If it intervenes, the effect of its intervention would be it has to regulate the current term if it grants the application by the IEC. And the only way to regulate the current term is by extending it. And it can extend the current term if it accepts the argument of supervening impossibility, that because of the situation of COVID and because of the impact on the right to life, it is impossible to hold an election, and therefore it is impossible to comply with the constitutional obligation. And that impossibility means that the elections should be postponed. So if it upholds that argument, it has no choice but to postpone the election and to extend the term of office, which means that these municipal councillors remain in office for a period longer than that envisaged by the Constitution until February next year. There is still the alternative argument, which is they do not have to expressly say that your term of office is extended, because doing so would be a direct breach of the Constitution. But they can say that the IEC's failure to conduct the election is an unconstitutional failure, and the court's own order, and the court can suspend its own order under Section 172(1)(b). The court's own order is suspended until February next year. If they took that approach, what would then happen as a matter of practicality is that the municipal councils will remain in office until February next year. If the court dismissed the entire application and simply decided that the application either falls outside of jurisdiction, or there are no grounds of urgency, or that the merits are bad, the municipal officers, councillors must leave, and a new election must be convened. There will be no other choice otherwise.
I would imagine some of the parties who want the election to go ahead would argue that that would be a judicial overreach, because when it comes to Section 159 and the term of office of these municipal councils, I would imagine they would argue that it is not within the purview of the Constitutional Court to make such rulings, and they probably would want to argue that a constitutional amendment should be taken back to Parliament.
Yes, that is true. That is, in fact, the argument of the DA and the argument of CASA. What they say is that the Constitution does not contain an express power authorizing the courts to suspend the election, or to postpone the election, or to extend the term of office of a municipal councillor. But that should be contrasted with what the IEC says. The IEC says where there is a supervening impossibility, the Constitution doesn't envisage that the impossible should happen. Where there is a supervening impossibility, there has to be a power located in the judicial function to grant an order that would be just and equitable to accommodate the impossibility. Take, for instance, a situation of war, or take a different disaster, which is not an infectious disease, but an earthquake. So it's those types of supervening impossibilities, a war and an earthquake, which would render the practicalities of holding an election impossible. What they say is that in those scenarios, it is untenable to argue that an election must nevertheless go ahead if South Africa is invaded by a foreign country, or if there is a domestic war, or where, for instance, there is an earthquake. So it's those extreme instances that the IEC uses to bolster its argument. But as I say, that all of this may turn out to be irrelevant, because the court may well be satisfied that they don't have to engage on the argument of supervening impossibility. It's enough for them to grant the declaration of invalidity, because the IEC admits that it will not comply with the constitutional obligation. And if it does so, then there is, in fact, no overreach, and there is no breach of separation of powers.
Well, we have to leave it there, but thank you so much for giving us that clarity in terms of the arguments that will be put forward at the Apex Court today. And that was Advocate Tembeka Ngcukaitobi, a member of the South African Law Reform Commission, discussing the legal implications of a postponement of an election as the ConCourt prepares to hear arguments that are for and against the postponement of this year's local government elections that are scheduled for October 2021.